Whether he was arguing major antitrust cases or defending small innovators against larger companies, John Haven Chapman was always a dedicated advocate for the underdog. While still in law school, he held one of his first jobs in the Boston Public Defender's Office.
He was defending a man who was not well off. I believe he was a minority, and there were a whole bunch of people that he got charged with assaulting a policeman, and John had to somehow get this guy off, and he really cared for him. He felt that he was not really violent, but that just the situation had gotten a bit out of hand. And so the policeman who was testifying against him was on the stand, and John noticed that there were a whole bunch of other policemen in the courtroom that were waiting to go on for other cases, sitting right in front of him. And John was able to bring up just the right expression that when this man had raised some object high over his head, he asked the policeman, and glancing off to the other policeman, reminding him that he was in the other room, said, "Did you really feel threatened when my client raised this object?" And the guy said, "Nah." And that was the case. And so he immediately then moved for dismissal, because if he hadn't been threatened, then there wasn't any case. And the judge got a bit mad, and he granted the motion. He said, "But if you ever pull one of those Perry Mason moves on me again, I'll finish you off."
With a law degree from Boston University and an engineering degree from Brown, Chapman helped obtain patents for Xerox's Palo Alto Research Center, known for innovations involving the mouse and laser printer. He also wrote and filed Bob Metcalfe's patent for the Ethernet in 1975. Metcalfe, now professor of innovation at the University of Texas, explained the significance of the Ethernet as the Internet standard plumbing and the challenge John faced in writing a patent for it. After assisting on antitrust cases involving IBM and AT&T for the Justice Department, Chapman continued his work on these critical competition issues as an attorney for CCIA, representing us in the U.S. District Court review of AT&T's reorganization plan. In helping foster the breakup of AT&T, Chapman had a hand in speeding competitive fiber-optic long-distance networks that became the backbone of the Internet, not to mention cheaper phone bills, cordless phones, fax machines, and cell phones.
I think those were John's glory hours, should be documented. I hope they are documented somewhere.
He understood intellectual property, and I think one of the most important cases that his amicus really carried the day for CCIA is a case called Sega Accolade, where people to prevent competition would build interfaces that were proprietary, where in the process of trying to make your product compatible with somebody else's product, you would have to reproduce the software and therefore technically violate copyright. In the Sega Accolade decision, which is an extremely important precedent, the decision basically was modeled after the front of the court brief that John wrote for CCIA, and it said that reverse engineering for the purposes of compatibility of interfacing is fair use of copyright.
John was always there for CCIA, always willing to help out, extremely broad-looking, creative in a legal view of the computer industry. He had the ability to understand the technology, what it was bringing to the marketplace, and the issues around competition in the marketplace, and at the same time be able to translate that into a legal brief or a documentation that would bring forth the issues at hand. He was extremely good at it. It was an honor knowing the gentleman.
I think he was proud of the work he did at Xerox. I think he was proud of the work he did at the Justice Department. and at the Computer Industry Association. After he left CCIA, he went to Gartner Group. He started their telecommunications practice. He taught antitrust law at Columbia Law School.
All the while, he continued to help smaller clients facing big legal battles.
There was some litigation that I had going against a larger company that I believed had not honored some contract arrangements. And what was interesting was that John really gravitated towards situations in which a small guy would provide be running up against a large guy. He loved taking on cases like that.
He was my lawyer for 4 or 5 of those years, representing me against a massively large company who allegedly absconded with technology that was patented. The market valuation of that company was like at $80 billion. So you're talking about a massively large company that had unlimited resources. It was just 2 young guys. They were relatively young. He was older than me, but not a lot. And I thought at first that he was sort of like a Don Quixote. But then seeing him in practice, I then learned he was actually the Dennis Potvin of the legal profession. And what I just absolutely loved was how he hit-checked the 4 corporate lawyers or the counterpart. And they did all manner of stuff to swamp us, and he just deflected it and just kept pounding at them.
Chapman is remembered for his deep love for his family.
2 boys and 2 girls that meant the world to him.
A hockey enthusiast, Chapman was known for his fierce competitive spirit on the ice.
The last game that he played, and he knew that just his body wasn't going to take it anymore. I mean, people don't generally play hockey into their 40s. It's just too tough a game. And he said he really wanted to make that, he played forward, and he really wanted to make that shot, and he saw the goalie, and he saw the opportunity, and he wanted to place the puck just over the left shoulder of the goalie for his final shot of his lifetime in hockey, and he did, and he got it right in the goal.
And he brought that competitive spirit to his life's work, fighting the good fight.
He did his homework. He knew the outcome before it started. He had it all mapped out in his mind and just executed flawlessly. So he just did outstanding work, and he took great pride in the implications of his work in terms of there being justice and proper, equitable outcomes for participants in our industry.
It was so important to him to believe in what he was defending, and so the truth actually drove him. And I know that that's a difficult thing. Everyone is entitled to representation. Sometimes you have to represent the evil side of the business, but not him. He was committed to the truth.
I think he's a person who deserves to be remembered because of his both his skill and his interest in not just taking the most lucrative job that one can get, which he, with his litigation skills, had no problem finding work, but he took on cases that in which he felt that somebody had been wronged, and that he had the ability to make it right.